right, we're here for our first regular review on both parents. We've made some time for each parent to be able to talk to their attorney before we get started. And now we're going to head into the review. May I have the names of our participants, please?
Lee Heiss, lawyer, guardian ad litem.
Nastasia Thomas, counsel for the department.
Christy Brinker, Fostering Solutions caseworker.
Michael Brooks, I represent the father, Skylar Stage. Mr. Stage,
Yes, sir.
identify yourself, please.
Skylar Stage.
Thank you. I'm going to go ahead and mute you, Mr. Stage. There's your microphone over there is picking up everything. So when it's time for you to testify, I'll certainly offer you the opportunity. But if you need something before that, just go ahead and raise your hand and let me know.
Michael McFarland, representing mother. Please introduce yourself.
Bonnie McGee. Okay. Ms. Heiss.
Thank you, Your Honor. The foster parent brought the child to see me, and the child is doing so well. And she's been having her visits with her mother, and the supervisors are able to help mom with improving her skills, which are pretty high anyway. And then, as you see, the court report tells us the details about some of the things that we need. I believe we still need birth medical records. So I'm going to check on what we need to do to get the birth medical records. I assume mom can release them, but there are some relatives that are being assessed for placement, and the child's needs are all met in the current placement, and she has siblings, and she has all the developmentally appropriate things that she needs in this placement. So we're looking forward to another successful review period. Thank you.
Great. Testimony today, Ms. Thomas.
Thank you. If Ms. Brinker can be sworn in.
Yes.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do. Thank you.
Go ahead.
Thank you. Ms. Brinker, for today's hearing, you have prepared a court report, and inclusive is the case service plan for each parent, the psychological evaluation for mom, and then an early on evaluation for the child. Are there any other updates, modifications, or more documents that need to be addressed today?
Not at this time, no.
Thank you. And you started this case, I believe your court report says October 10th, you became the caseworker?
Correct. It transitioned to me, yes.
Okay. And since you've taken over the case, have you had the opportunity to meet with either parent?
I actually, after filing the court report, Bonnie and I did have a conversation. Mom had a conversation on the 2nd, I believe, and we were able to chat about her case service plan and services and referrals and that kind of thing. So yes, I have not had the opportunity to meet with father though.
And did you, I believe your proof of service indicates so that he was given a copy of the report through the jail?
Correct.
And at this time, do you believe that there's still a risk of harm to the child if the child were to be returned to either parent today?
Yes, I do.
Briefly summarize what that risk of harm is.
Sure. So Shelby was brought into care due to allegations of domestic violence, also substance abuse. We're still very early in the case planning process, and Bonnie has been able to undergo her psychological evaluation. However, she has not made any progress with any of the recommended services, which is something we did discuss last week.
And it has been a very short review period for Dad at this point in time. Have you been able to send the jail any correspondence for Dad or any more packs or anything to help his compliance with his case service plan?
The parenting book was mailed to him, and then the first 2 chapters of the workbook for the parenting skills were also mailed to him, but that is the extent at this point.
Okay. And do you believe that it's necessary then or let me strike that. Do you believe that the child then is in the least restrictive environment to ensure her safety?
Yes.
And do you believe that the caregivers are exercising the reasonably prudent parent standards?
Yes.
And the child has age-appropriate activities to utilize in the home and has a normal home environment?
So many toys all over the living room. They've taught her baby signs, which I shared with Bonnie, and you were actually just talking about. I was teaching her the baby signs, the 3 that baby Shelby does know. So yeah, so very age-appropriate developmental toys throughout the home.
And is there anything else that you'd like to bring to the court's attention from your report or the psychological or early on assessment?
Not at this time, although I do believe that there is an update that I did forget about, that Bonnie actually just let me know. Father was sentenced, I believe, on Monday and got 12 months that he will be incarcerated, credited for time served, but he is expected to be incarcerated until, I believe, May.
Okay.
May 20th of 2024.
Okay.
And then after that, he still has the pending criminal charges in Indiana.
Okay. There was one more question I had. At the last hearing, the court wanted the affidavit of parentage. Did that, if the agency was ever able to secure that?
I am not sure about that. Sorry.
Okay. So that's not something that was on your radar?
No.
Okay.
Has his name on it and wishes.
Okay. Well, I have no further questions of Ms. Brinker, Your Honor, and would move to admit the court report with the attachments.
No objections.
No objection.
No objection.
Thank you. It is received, along with the affidavit of parentage. Questions for this witness, Mr. Brooks?
May I assume that the affidavit of parentage reflects my client is the biological father?
That's correct.
I have no questions.
Mr. McFarland, any questions for this witness?
Yes, I do. My client indicates that she's been thinking about either inpatient or outpatient drug treatment, which is a recommendation, correct?
Mm-hmm, correct.
Yes, okay. McCullough Vargas is local and they have an intensive outpatient program. Is that something that you would explore to see if she could do that?
Absolutely, yes. That's the first I've heard of it. When her and I had talked, she had planned on just going to Adrian Counseling and Psych. So she was going to follow through with that, but absolutely that would be an option that I.
She's of the opinion now that she needs some treatment. And do you support that that's a good decision of hers?
Yes, absolutely.
Okay. Is that where she should be spending her first focus on this case right now?
Is counseling towards her substance abuse issues? Yes, absolutely.
And then probably secondary is then going to be the psychological evaluation recommendations. Would that be accurate?
Well, that is the psychological evaluation. Was one of the recommendations was the substance
Okay.
abuse. So.
Nothing further.
Questions, Ms. Heiss?
So the psychological evaluation has recommendations, maybe 4 of them. Has this document been given to mother?
Yes, it was provided to her.
Okay.
And we did discuss it when we talked on the phone last week as well. And I asked if she had any questions about anything or.
Okay. So she has elevated stress level, unhappiness level, substance use disorder level, likelihood, and then abuse scale is elevated significantly. Is that right?
That is correct, yes.
All right. So then the relatives who are being assessed, has anyone returned their paperwork to you since the court report came out?
Nothing, there's not been any new developments regarding the potential placements. All the placements all have home safety issues, and then we're still waiting on, again, criminal clearances and such, so.
So if we need the hospital birth records so that early on can accurately assess the child, right?
I believe so, yes.
Is there anything you need from the court order or from mom to sign a release so you can get those medical records?
I probably needed to clarify with the previous caseworker, but I felt like she already had obtained them, so I need to verify that.
Very good. Nothing further.
Any redirect?
No, Your Honor.
Thank you for your testimony. May I return to your seat? Any other witnesses, Ms. Thomas?
No, Your Honor.
Okay, Mr. McFarland?
No witnesses?
Mr. Brooks?
Mr. Stage, do you have anything you want to say to the court?
Yes, hopefully there's a way for you to unmute on your end, possibly, or you might have to ask for some assistance to do that. Let's try that one more time. Oh, there we go.
All right, so I got told that I would possibly be able to get visits through me being incarcerated with Shelby. I talked
Oh, wait
to
a
the
minute.
jail.
Sir, wait a minute. You got to be sworn in. Before you start testifying, you got to be sworn in.
All right, let's get it.
Sir, can you raise your right hand, please?
Yes, sir.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Okay, also, I'm gonna need you to go really slow and speak very clearly because there's a lot of like echo from where you are, and it's making it hard to understand.
Yes, ma'am.
What's on your mind, Mr. Stage?
I got told I was going to be able to get visits set up with my daughter while me being incarcerated. And the jail said that without a court order, they're not going to allow that to happen.
Who's not going to allow it to happen?
Hillsdale County Jail, they said they would not allow it unless there was a court order.
This court has no control over the jail system, sir.
All right, let's scratch that. I'm straight.
All right. Anything else?
No, sir.
Thank you.
Cross-examination?
Mr. Stage, I just have one question. Mr. Stage, do you have like a caseworker or point of contact within the jail system?
I don't know her name. I think something Nolan. I talked to her once here, and she's the one that said I was going to be able to get visits and stuff. I mean,
Okay.
another thing, I've got the packets and the book to do the parenting stuff, but I got told I was supposed to get envelopes within the packet, and I haven't received those either. So I've completed 2 of the workbooks. I just need to send them out. I have no envelopes.
Okay. Okay. And if you were to receive those envelopes, could you secure the name of the individual that might be a point of contact for the agency?
Yes, ma'am.
Thank you. I have no further questions.
Mr. McFarland?
None.
All right, thank you for your testimony, Mr. Stage. Your DHS, or I'm sorry, your foster care caseworker, which is spearheaded by the agency, Ms. Brinker, is here today. She's heard you and your request for envelopes as well. So you can, I'm sure, expect to see those. If the court were to issue an order for visitation, is there any kind of limit or type of visitation that the jail would prefer, if you know?
I don't know exactly. I could figure it out and let the caseworker know though.
Okay, thank you. Perfect. Any questions based on my questions?
No, thank you.
No, Your Honor.
No.
I have nothing further.
Okay, thank you for your testimony. All right, anyone you'd like us to hear from, Ms. Heiss?
No witnesses today. Thank you.
Comments, Ms. Thomas?
I have none, Your Honor. Thank you.
Mr. Brooks?
No, I have no further witnesses, Your Honor.
Any comments in closing?
No comments at all.
Mr. McFarland?
None, Your Honor.
Ms. Heiss?
No comments. Thank you.
Well, the court finds all interested parties were given notice for purposes of today's first review hearing. It's good to see that Mr. Stage has an idea of at least what will be happening with his Michigan case and has had the opportunity to look at workbooks. The court order will address that parenting time should be provided by the jail for him, at least on a virtual basis. Moving forward, and then we'll leave it to Ms. Brinker from there to coordinate that for him. She's also in satisfaction of her obligations, of course, as caseworker for purposes of working on the reunification of this child with a parent. Mr. Stage is not able to take, obviously, care at this time of the child, given his circumstances, as well as some of the other challenges that were identified at the outset of the case that he will need to continue to tackle and work on as he makes his way through his sentence as well and faces perhaps additional criminal proceedings in another state. The child is also not able to return to Ms. Bonnie McGee at this time for the reasons cited in the adjudication and initial disposition. The update on that is that she still needs to engage in some substance treatment, some parenting education, to find a place that she would be able to stay with the child, and some employment, and demonstrate the ability to take care of the child. As it is now, the child is at significant risk of harm if she were to be returned to either child or either parent, and is in the safest and least restrictive home for the time being as the parents work on the barriers holding up reunification at this moment. I also find Ms. Heiss to be in satisfaction of her obligations as guardian ad litem.
Thank you.
And thank you to our attorneys, of course, for their services as well. The case services plan will continue to govern and measure the progress of the parents. The referrals will continue to be made, and the foster care caseworker will continue to work with the family in the coming months. There's a show cause filed late last week based on continued drug usage by Ms. McGee, despite her being in month 9 of her pregnancy. The court did issue that. I'm not sure if she's been served. And let's talk about it after appearances.
Lee Heiss, lawyer, guardian ad litem.
Ms. Sasha Thomas, counsel for the department. Our workers are Christy Brinker and Ashley Beach on this matter, and Your Honor, I have not had contact with them. So I'm not sure if they were intending to log in. I am not sure. I haven't gotten an email that Ms. McGee was served. So.
That she was or was not?
I have no proof that she was.
Okay.
Michael McFarland representing Ms. McGee, Your Honor. She's not in the hall.
Thank you. She's nowhere. She on Zoom. Ms. Heiss, what are your thoughts on this? You just want us to move it out?
I'm going to need to check my court rules, whether we can progress. This is critically important, but I need just a minute. She hasn't been served. The agency hasn't been served. I'm fine to even delay a half hour and see if we can get everybody here and get her served. It's critically important.
I can stick around, Your Honor.
I agree with Ms. Heiss on this matter.
Okay. Well, I can give you a recess on this case. We can get started on some of the other matters that are pending for this morning, and then you can let me know when you're ready to come back on the record. 2, 3, 1, 7. Okay. Good morning, everyone. This is, I'm sorry, I'm muting all of our participants that we're getting some noise from. There we go. All right. So the department filed a request to remove the child concerned by this petition, which is the second petition. Well, it's a supplemental petition in this case, for a new child that was born very recently, February 14th, 2024, asking for removal from mom. Mr. Stage also is a putative father at this point. We did attempt to get Mr. Brooks to join us this morning, but I think there was some confusion about whether or not the hearing would be at 3 o'clock or 9 o'clock, which I do want to.
I did hear from Mr. Brooks' administrative assistant, and he should be available by Zoom in about 15 minutes.
Great. Okay. So he will be joining us approximately 15 minutes from now. At this point, Mr. Skyler Stage is the putative father. We don't have any indication that by way of David of parentage, perhaps yet, I don't know. We'll give you a chance to talk to Mr. Brooks about that, Mr. Stage, but as of right now, you are not quite a participant in the sense that you are as it relates to the other child, because you have not been found to be the legal parent at this moment. So today's hearing is a hearing on the petition, the supplemental petition that also requests that removal. I have to decide whether or not to authorize the petition and whether or not the removal is appropriate. I have the names of our participants.
Lee Heiss, lawyer, guardian ad litem.
Nastasia Thomas, counsel for the department. Ms. Harvey?
Sarah Harvey, DHHS.
Michael McFarland, representing Ms. McGee. Please introduce yourself. You're muted, Will.
Bonnie McGee, mother.
Thank you.
Okay, Mr. Stage, I did have to mute you on your end. If you would please unmute and give us your name for the record.
Skyler Stage.
Thank you. Welcome. All right. Looks like we also have some foster care caseworkers that have logged in from Fostering Solutions, as well as a supervisor from DHS and their foster parent. So welcome to all of you as well. Mr. McFarland, I understand you've had a chance to talk with your client.
I have. First of all, my client just given birth. I wanted to make sure that she was able to participate, that she was not under any medication. She had oxycodone for pain, but she just says those results are, she does not feel she's under the influence at this time, just Tylenol and other painkiller, Your Honor. But at this point in time, she does not wish to have the petition read. She has received it. I went over it with her. No Native American heritage on her part or possible father's part. With the possible criminal liability, the fetal endangerment, we would be looking for a no contest plea in this matter. As far as placement, she'd like her parents considered first. They're found to be unacceptable. She has another child that, and we're not going to use the children's names, but she'd like this newborn placed with the other child that's in foster care. Yeah, I did go over her rights with her.
Right. So is she contesting at this point the removal?
No, Your Honor.
All right. Thank you for those pieces of information. That does answer nearly all, in fact, the questions under 3.965 governing our proceedings on a preliminary hearing. Deputy Ames, would you swear in Ms. Bobby McGee for us, please?
Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Ms. McGee, do you have a copy of the petition that was filed yesterday?
Yes, I do. It's in my email, but yes, I do have it.
Good. And is everything that Mr. McFarland just shared with us accurate?
Yes, ma'am.
All right. Thank you. Very good. Any position on the request to enter no contest plea?
I have no position.
I have no objection.
Very good. Ms. Heiss, would you find it to be in the best interest of this child for me to receive the plea?
Yes, Your Honor.
Okay, well, Ms. McGee, then I'm going to go over your rights with you and as part of that process. If I accept your plea, you are giving up a right to a trial by judge or trial by jury. The right to have the petitioner prove the allegations in the petition by a preponderance of the evidence. The right to have witnesses against you appear and testify under oath. The right to cross-examine witnesses, and the right to have the court subpoena any witnesses that you believe could give testimony in your favor. You would always have your attorney, you have a right to an attorney at each and every hearing as well, so Mr. McBrown would certainly be there to help you with all of those things at any trial. Do you understand you'd be giving up or waiving your trial rights that I've just went over if you enter a no contest plea?
Yes, ma'am.
All right, as it relates to a no contest plea, essentially what that means is without you saying anything, I will effectively assume that the allegations in the petition are correct and look at whether or not those violate the statute and require the court to intervene. Do you understand that?
Yes, ma'am.
All right. With regard to the consequences of that plea, or in other words, what will happen, the court will do the following. There will be continued investigation by the caseworker to see what the problems are in your family and how and whether they can be solved. The court could dismiss the case if there's no need for the court to be involved. If it appears that there's a problem that may be solved, the court can make the children or the child a temporary ward of the court, place with mother or father or with relatives or in a foster home, and order programs for you and your child, such as counseling, drug and alcohol treatment assessments, or parenting classes. If it appears you will not be able to provide a proper home for the child in the reasonably foreseeable future, the court could terminate your parental rights. In regard to the plea itself, plea can also later be used as evidence in a proceeding to terminate your parental rights. Do you understand the consequences of your plea, Ms. McGee?
Yes, ma'am.
Do you have any questions about any of the information I've given you so far?
No, ma'am.
Is anyone making you enter a no contest plea?
No, ma'am.
Has anyone threatened you in any way to get you to enter that no contest plea?
No, ma'am.
Do you feel that you are under the influence of anything that could get in the way of you understanding what you're doing right now, like any drugs that you might be on through the hospital or anything else?
No, ma'am.
Has anyone promised you anything in order to get you to enter a no contest plea?
No, ma'am.
Did you say that your decision to enter a no contest plea is one you've made of your own free will?
Yes, ma'am.
Ms. Thomas, at this point, look for you to establish the factual basis for the plea, please.
Thank you, Your Honor. If Ms. Harvey can be sworn in, please.
Ms. Harvey, come on up to our witness stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes. Before we get into that, I don't think we did this on the record. I know we discussed it just briefly by sidebar before we began, but the reason for the no contest plea, Mr. McFarland?
We did put this on the record. I said fetal neglect, Your Honor.
Okay.
Which would be a crime.
And that is based on?
The child or the mother testing positive multiple times, including just days ago, for controlled substances.
Thank you. All right. Very good. Go ahead.
Thank you. Ms. Harvey, can you state your role in this matter?
I'm the CPS investigator.
Thank you. And as the investigator, were you able to establish that the child, I'm sorry, back up. As a CPS investigator, can you explain your process and how you formulated the allegations that are contained in the petition?
Yes. We received a referral that MS had been born, and that at the time of birth, mother did not test positive for any substances. However, there was an indication that she has been in foster care, and during that foster care case previously, she had tested positive. So I went over the testimony from the previous investigation and received a copy of the court report from the from the foster care worker, which did show two positive tests for methamphetamine in the third trimester. The court results from MS are still pending. Currently, nurses indicate that there are no withdrawal symptoms, but we're still waiting for those results. They're trying to hurry those along as fast as they can. But we did have the 2 positive results on record.
Okay. And were you able to speak with Ms. McGee in this matter?
Yes, I did. I spoke with her yesterday.
Okay. And had she admitted to any use within the last?
Yes, she indicates that her last day of use of methamphetamines was January 28th.
And the current home that Ms. McGee is living in, is that appropriate for the child to be sent home to?
Fostering Solutions did the placement assessments on that home, and they indicated that due to safety concerns in the home, it was not appropriate.
And you mentioned that there's already another child in care that was born to these parents, correct?
That's correct.
And the reason that child was removed, do you recall the reason the child was removed?
I believe it was substance use and domestic violence and housing instability.
From review of the court report, were you able to determine whether the parents had complied with and benefited from their current case service plans?
I believe it indicated that there was a lack of compliance and minimal benefit at this time.
And were you able to speak with Mr. Stage in the last couple of days?
No, I have not been able to speak with him yet.
And to the best of your knowledge, he remains incarcerated?
Yes.
One of the questions that will likely be asked is the placement plan. The petition asks for the court to place the child with the department for parent supervision. Do you happen to know what the placement plan for this child would be if the court?
Yes, the current placement would be in the same licensed foster care home as the older child, SS.
And are you aware of any sibling visits that have already occurred?
Yes, there have been 2 sibling visits already that have occurred this week.
Is there anything else that you would like to state for the record to help the judge and make her findings?
No, just that it seems that the same issues that brought SS into care are still evident today.
As it relates to reasonable efforts, I know that there's a lot of citing back to the foster care case. Were you able to offer any additional services since your investigation?
Yes, we spoke about services. I kind of wanted to get a plan for her case service plan and how she felt about it and what she was looking forward to. And we did talk about the substance use, as that is my main concern in this case. I offered to assist her with inpatient. She doesn't feel that inpatient substance use treatment is appropriate for her at this time. She's afraid that it will impact her employment, and she's only interested in outpatient right now.
Thank you. Your Honor, I have no further questions for Ms. Harvey regarding the factual basis of the plea. Questions?
I do. My understanding is that we do not have the umbilical cord results yet, correct?
That is correct.
We don't have any doctor's reports indicating that the child is born addicted or that there's any consequences of mother allegedly using controlled substances to the child, correct?
As of today, that's correct. They're still monitoring as the child and the mom have not been discharged yet.
Okay. So do you know the particulars as to why the home, I believe it's her parents' home, correct?
Yes.
Why that is not an acceptable place?
I don't know. I myself don't know the particulars on it. I didn't do the assessment. The fostering care, the fostering solutions foster care worker would have more details on the specifics for that.
So you're not going to be the ongoing worker, correct?
That's correct.
Because what happens if the results, the umbilical cord results turn out to be negative and there is no negative side effects to the child from my client's possible addiction?
Then we go back to look at the reasons that SS would be in care, which would be housing instability and the domestic violence. Until very recently, there was no contact order between the 2 parents that was continuing to be broken. So that would still indicate an issue there. And we still have the housing with that assessments have indicated is not appropriate. While she is looking for housing, she has not gotten any yet.
Thank you. Nothing further.
Ms. Heist?
I have no questions. Thank you.
Any redirect?
No, Your Honor.
All right, thank you for your testimony. May I return to your seat? Any other witnesses?
No, Your Honor. Your Honor, just as it relates to placement, if Ms. Brinker can respond in, please. Thank you.
Christy Brinker?
Thank you, Your Honor. Please raise your right hand, Ms. Brinker. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Good morning, Ms. Brinker.
Good morning.
Can you please state your role in this matter?
I am the foster care worker for the older child in care.
And will you be, if the court removes the child, will you be the foster care worker for this child as well?
I will, yes.
Okay. And it sounds like the plan currently is for this child to be placed with the older child in a licensed foster home?
Correct.
Okay. Can you briefly, I'm sorry, have you had the opportunity to explore potential relative placement for that older child?
Our agency did do relative searches, and all of the relatives that were given at the onset of the case have all been denied for various safety concerns, whether it be criminal history and or safety concerns in the home. All of the relatives have received a denial letter at this point with the opportunity of things that needed to be corrected. And we have not heard back for any reassessment from any of those relatives.
Does that include Ms. McGee's parents?
It does, yes.
And, okay. And so you have not reviewed that home recently, is that correct?
Correct.
Okay. Thank you. Your Honor, I have no further questions for Ms. Brinker.
So would you review Ms. McGee's mother's home to, and she would like you to do that?
Yes, I mean, if Mrs. McGee's mother would like us to come out and reassess her home, we would absolutely welcome that.
Okay, so the denial letter is from an earlier placement request, not for a placement request right now, correct?
Correct. I believe that they probably just received that within the last 30 days though. So they're aware, they were verbally told and then they received written list.
Because I don't have access to that denial letter. Can you tell me the particular criminality concerns?
I actually do not have that in front of me, and being there was other family members, I can't really speak to that at this time.
So we don't know that that house is not acceptable if we don't have that denial letter, right?
I just don't have the denial letter, the particulars in front of me because our licensing department handled that denial. I do know that there was still pending CPS charges from Texas that we were still waiting to obtain. I believe Miss McGee's mother was requested to obtain that, and we haven't received those.
Do you happen to know any of the physical barriers in the house just offhand?
I believe there was not suitable beds. And I honestly, I don't want to speak to it because I don't want to get them all confused. I believe one of the homes had a wood burning stove and there was no area for, you know, the older child and to walk around as she was just learning to explore. I understand it's a little different for a newborn, but I believe there was not appropriate sleeping arrangements.
Okay, so it sounds like we'd have to do another inspection of the house then, correct?
We can absolutely do that, sure.
Okay, no more questions, Ronna.
Ms. Brinker, in your work with the older child, SS, we've had a psychological evaluation of this mother, isn't that right?
Correct, yes.
And her abuse scale was significantly elevated back in July, is that right?
Yes.
And do you think she has partaken in services and benefited from services to the extent that we can say that that abuse scale has been reduced?
She has not. She engaged initially and engaged with the McCullough and Vargas for about a month and then discontinued services. And that is when she relapsed. She re-engaged right at the last court hearing. And then I actually just checked in with her counselor just to touch base again to make sure that we had the psych eval and that all the appropriate services were going to be in place so that we can get them reunified. And she states that she has not heard from Ms. McGee since February 5th. And she knew that she had court that day and wasn't sure what was going to happen due to the show cause due to her positive drug screen. So that's 10 days that she did not have contact with her counselor or peer coach. So there are definite concerns about her ability to follow through with the outpatient treatment at this time.
Thank you. I have nothing further.
You redirect? No, Your Honor.
One follow-up question, Your Honor. Do you think that your case service plan for this newborn child is going to be any different than the existing case service plan? For example, would you like a family team meeting to explore that?
I mean, we always welcome family team meetings.
Thank you. Nothing further.
All right. Anyone else you'd like us to hear from?
No, Your Honor.
Mr. McFarland?
As far as the paternity issue, on that issue only, I'd like to question my client, Your Honor, and the ICWA issue.
Go ahead.
Those
She
two.
has been sworn.
Bonnie, if you could unmute yourself. I know we had a discussion. I asked you, do you have any Native American heritage, Indian blood on your family or the possible father's family that you're aware of?
Nope.
Okay, and do you know who you believe the father to be?
Yes.
Who would that be?
Skylar Stage?
Is there any possibility it might be somebody else?
Nope.
And if you are approached with an affidavit, an acknowledgement of paternity, would you sign it indicating that he's the father? Or
Yes.
what's your position? Thank you. And I guess if I can just ask one question on placement, Your Honor. Thank you. Do you prefer your child to be placed, the newborn to be placed with your mother, or would you rather the newborn be placed with its other sibling right now for bonding? What are your thoughts?
Honestly, with her sister, like her to be placed with her sister.
Thank you. Then I withdraw any concerns I have with family placement, Your Honor. Nothing further.
Did you have any questions for this witness, Ms. Thomas?
I do not, thank you.
Ms. Heiss?
I have no question. One quick question. You are bottle feeding this child formula, is that correct?
Correct.
Thank you. I have nothing further.
You look like you might have another question.
Well, maybe another witness. I'd like to call Ms. Brinker regarding parenting time. I think she'd be the person that'd be appropriate to ask that.
Very good. Go ahead. She is also under oath.
Ms. Brinker, with a newborn child like this, you would agree that the mother-child bond is especially important, correct?
Yes.
What would you propose or suggest for parenting time for my client and the newborn?
Well, the minimum is 3 times a week. I do believe we have that already set up with the older child at this point, with the supervised visitation and then 2 additional visits. Also, I am a little, I'm concerned about Miss McGee, and I think that the removal could potentially be another trigger for her. So I'm absolutely willing to go above and beyond on this and get her visitation as much as we can possibly schedule.
So if she demonstrates a history of sobriety from drugs, I presume you'd be testing her, correct?
Yes.
Would you consider expanding that if there's no safety concerns then?
Absolutely.
Nothing further.
Any more questions for any other witnesses?
No, Your Honor.
Comments?
No, Your Honor.
Mr. McFarland?
No, Your Honor.
Ms. Heiss?
No comments. Thank you.
All right. Well, the court finds all parties were given notice for purposes of today's preliminary hearing and request for removal. I do find that at this time, with the issues with where Ms. Bonnie McGee is staying, that the safest and least restrictive placement for this new child is, in fact, under the discretion of the Department of Health and Human Services, which I believe is also the plan is to place this child with the sibling. Obviously, there are benefits to that. This is a situation where mom's housing is not appropriate for the child. She also has some services that she needs to continue. She needs to follow those recommendations to address the things that were raised in the psychological evaluation. She needs to do some parenting education around how those issues could affect her ability to parent a child safely. I do want to recognize, and I don't know that we have any drug test results right now, but I do want to say that I did ask Ms. McGee to stop using methamphetamine as soon as possible under threat of incarceration, but I know that it's a difficult thing to struggle with addiction. And I just want to say that I'm glad to see that she was able to refrain from using at least from January 26th until the child was born, and that the child is not showing any signs of withdrawal. So I know this is a difficult hearing, and I am removing this child, but I want to take a moment to recognize that Ms. McGee was able to at least make that progress since January 6th. So congratulations to you on that. That will certainly influence the court moving forward as far as what kind of parenting time. I would encourage the department to have a family meeting on that and set up as much frequent parenting time as could be organized between this mother and child. But I do find, as it relates to the petition, that there is a violation of the statute as it relates to provision specifically around the care and maintenance of the child, the necessary medical and care necessary for the child's health, in that the use of methamphetamine during the pregnancy has subjected the child to a substantial risk of harm to the physical health of the child. I also find that the housing and the unremedied issues that were visited on the record contribute to support of the violation of that provision by probable cause. And secondly, that those same facts and circumstances support that there's been a violation of the statute MCL 712A.2b. I think this is for around the home or environment of the child if I were to place with mom. The putative father is, of course, Mr. Skylar Stage. Our next hearing, which would be the disposition, I will also set a putative father hearing. Mr. Brooks has joined us by Zoom, so I'll make some time after this for him to talk with his client about steps to be taken on that point. But we'll look at that issue when we come back for disposition. As it relates to removal, okay, so yes, the plea, back to that for a moment, sort of jumping around, I apologize. The plea was knowingly, understandably, and voluntarily made with full understanding of the consequences. I have already found that the record supports that 2 of the pieces of the statute that are applicable have been violated, so jurisdiction over this parent is appropriate, and I am accepting her plea and will take jurisdiction over her for purposes of looking at whether or not she was able to make more progress on her case services plan between now and when we come back in the name of reunification with her and her child. In the meantime, I am ordering the placement of the child into foster care under the supervision, obviously, of the Department of Health and Human Services through the agency Fostering Solutions and specifically Ms. Christy Brinker at the moment. For the same reasons that the court took jurisdiction over Ms. McGee, I find that custody of the child with this parent does present a substantial risk of harm to the child's life, physical health, and mental well-being. Find further, for the same reasons, that no provision of service or other arrangement except removal is reasonably available to adequately safeguard the child from risks as described above, or before, I should say, that also support 2A. And just for the record, I'm under MCR 3.965C2. On 2C, continuing the child's residence in the home is contrary to the child's welfare for the same reasons. And D, I do find that reasonable efforts were made to prevent or eliminate the need for removal. And those were also explored on record through our caseworker. E, conditions of child custody away from the parent are adequate to safeguard the child's health and welfare. The child will be joining its sibling in a safe home where she will be able to visit as well as visit with parents. Okay. We've already visited the contrary to the welfare of the child factors and the reasonable efforts factors. All right. For purposes of initial disposition and the putative father hearing, let's see. We just had a regular review on this case. Our next review is not scheduled until April 9th, 2024. So rather than waiting that long to look at the disposition on the the supplemental petition, I could offer you some time in front of the referee, if you like, for the initial disposition and putative father hearing.
No objection.
No objection.
Yeah, no objection. All right. That would allow me to set that then for somewhere in the week of February 26th through March 1st. Is anybody out during that week that we need to be aware of?
Not here.
No, you're not. All right.
No.
How about Wednesday, the afternoon of the 28th at 1:30? And that will be for the, again, for the putative father hearing, as well as the initial disposition on supplemental petition. And then, of course, after that, and we'll communicate this with the referee, the regular review should be scheduled with the already previously scheduled regular review. Any questions?
No.
No. Okay. Thank you very much, everyone, for joining us. All right, we're on record for our third review, first permanency planning hearing in this case as it relates to mom's progress. And it looks like we still have a putative father issue potentially as well. So I look forward to the updates. May I have the names of our participants, please?
Lee Heiss, lawyer, guardian ad litem.
Ms. Stasia Thomas, counsel for the department. Ms. Brinker.
Christy Brinker, foster care worker.
Michael Brooks, I represent the father, Skylar Stage.
Good. At last we saw him was at Hillsdale County Jail. I don't see the jail logged in.
He may be in Indiana now.
Have you heard from your client by any chance, Mr. Brooks?
No.
A witness on this point, Ms. Thomas, or would you prefer to address it during the direct of your witness?
I can, if Ms. Brinker wants to be sworn, if you can please swear in Ms. Brinker to provide report. I do know that she gave that information to Mr. Powell in hopes that we could obtain.
There he is.
I think that. Thanks.
Hello, could you give us your name, please?
Skylar Stage.
Very good, thank you.
Michael McFarland, representing mother, Bonnie McGee. Please introduce yourself. Just saw her up there.
Yeah, she was here. Ms. McGee, can you hear us?
Hopefully she'll rejoin us, Your Honor.
Agreed. Very well. She always has the opportunity to join us in person as well as she so chooses. All right, your report, Ms. Heiss, whenever you're ready.
Thank you, Your Honor. I visited with the children in person and got to hold Monroe when she was brand new. What a wonderful placement we have for these children in our community, and all of their needs are being met while mom has second victory, inpatient rehabilitation. I would ask you to consider that the plan in the court report is appropriate, and expecting visits is out of treatment. So the girls are progressing and developing, and I think I'm going to cut it short until we have the testimony. Thank you.
All right, Ms. Thomas.
Thank you, Your Honor. Ms. Brinker can now be sworn in.
Ms. Brinker, come on up to our witness stand. I have to do the honors of your swearing in. Please raise your right hand. Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. Have a seat. Watch your step. All right. Proceed at will.
Thank you. Ms. Brinker, there's a report that we received for today's hearing, and on the cover page, it indicates no cover page on this one, but as it relates to the court report, there is the case service plans for mom and dad, and the drug screens that are noted in your court report, and then a progress report as relates to mom. Is there anything else that you have circulated since submission of this court report in those documents?
Yeah, there are no additional documents circulated. I do have an addition to the court report, though, that I do need to make.
Okay, yes, any updates or modifications, if you can provide those now.
Thank you. So I had checked with Ms. Dillon regarding the results from the DNA testing done with Monroe Stage and the father. The jail forgot to do the DNA testing that was originally scheduled for 3/29, and a new DNA test was ordered. It should have been received to the jail yesterday. and administered, and the turnaround time on that should be about 2 weeks. So that is our latest update.
Okay, wonderful. Thank you for that update. And is there anything else?
That is it right now. Thank you.
Okay. As it relates to the parent's progress during this review period, how would you describe their level of compliance with and benefit from their case service plan?
Yeah, so if we could just start with Ms. McGee. She had kind of a rocky first half of the reporting period. She did give birth to Monroe. However, when we were in court last, she had tested positive for meth. We filed a show cause, and then that was held in abeyance. We went back for the removal of Monroe to court at the end of February, where she had asked referee Fields specifically to be drug tested every day, which I arranged for her to do at LDC, in addition to our testing her during the parenting times. She claimed she had forgotten to go testing. She did not engage with any of her counseling or outpatient services. And we were working on getting her into the inpatient treatment. Referee Fields recommended us that we pursue Dawn Farms, which she did check in there on March 18th, and her progress. I did speak with one of her counselors, and she is progressing well there and expected to be discharged next week.
Wonderful. And as it relates to Mr. Stage, I know that it's a little limited as to what progress can be made, but if you want to provide any highlights from your court report on that point.
Sure. So Mr. Stage has been communicating with me. He texted me. Apparently, he can now text from jail. So he has been in communication with me. I did schedule a visit for him last Thursday to do a virtual visit. Unfortunately, the jail was unable to accommodate, so I will be rescheduling that visit. But the last update I had is that he is still incarcerated until May, in which time he'll be transferred to Indiana.
Wonderful. I know that in your report, you have an indication about parenting time with mom. During inpatient treatment, how has parenting time looked? And then when she is released, is there like a step down program, or how will parenting time take place after the 18th?
So I believe we have done two Saturday visits with her, where our staff has transported the girls up to her facility where she has been able to visit. One of the visits was held with her mother and father, and then last week's visit was just with Miss McGee. Those visits have been fine, no concerns. That is all that she's allowed to have in her space right now. So we are doing the maximum allowed. We are planning for when she gets out to going back to 3 days a week. She has requested that, and that's what our agency is planning for, is the 3 supervised visits a week.
Wonderful. And Your Honor, I'm sorry to ask this, but are we at a permanency planning hearing?
Yes.
Okay.
I can double check if you want.
No, I trust that. Ms. Brinker, for permanency for the children, what is
we should be, let me put it that way, but unfortunately, Ms. Fields did not set that for a permanency plan.
Okay, thank you. Well, then in that case, Ms. Brinker, if the court were to return the children to the care and custody of either parent today, I know that it might seem like a silly question, but can you just highlight the risk of harm?
Yes, of course. The risk, the removal of the children have not been rectified. As we know, Mr. Stage is still incarcerated and still facing criminal charges. So he does not have stable housing. Ms. McGee is, again, at inpatient treatment, also does not have stable housing.
Okay. And I know that in the historical context of this case, there might have been concern about mom and dad having communication. Do you know if it has been brought to your attention at all? If that's ongoing at all during this review period?
since Miss McGee, I know her communication was very limited with at her inpatient treatment. I don't have any knowledge of them having contact since she has been admitted. So since March 18th.
Okay, thank you. Your Honor, with that, I have no further questions of Ms. Brinker and move to admit the court report with its attachments.
Objections?
No objection.
Now that my client has rejoined, no objections.
No objection.
They are received. Thank you. Cross-examination, Mr. Brooks.
No questions.
Mr. McFarland.
My presumption is that when my client gets out of rehab, she should immediately schedule an appointment with you. Is that correct?
Yes, we've been communicating.
Okay, just want to make sure. Is she still asking for daily drug testing when she gets out?
She's nodding her head. Yes, we have not discussed the specifics. I am planning on touching base this week before she's discharged on Wednesday next week. So I'm planning on touching base this Friday to see what their recommendations for the.
Well, I'm taking her nodding her head as an affirmation that she wants to be tested daily.
Yeah.
Is that something that can be accommodated?
It is already in place, yes.
Okay. I know that she has a lot on her case service plan to accomplish. Where should her priorities be? If you could maybe put a couple of those in chronological order so she knows.
Yeah, absolutely. And she knows. We talk every time when we come out of court, and I reiterate every time I talk to her that her sobriety is her number one thing that she needs to focus on. Going to the outpatient program and engaging as much as possible. I think that the inpatient program has been really good for her and helped also reiterate that. And she has communicated that with me that she already has an appointment with her outpatient therapist at McCullough and Vargas, and plans on going to peer groups and has another support person already in place. So she has a ton of stuff already in place. So that is absolutely her number one focus right now.
Thank you. I have no further questions.
Ms. Nice.
Thank you. I noticed in your court report that you have a housing referral in. Isn't Dawn Farms able to help her with aftercare housing?
When I did check in initially just to check on her progress last week, they said that that was something that we could talk about more once we got closer to discharge. I think that it's something that they offer more so towards their longer stay patients. But again, I'll definitely be exploring that possibility because I think that being in a supportive environment, supportive, sober environment is definitely what she needs.
And in addition, your report points out that the place she plans to live has had significant substance abuse history.
Correct, yes.
And that she's, before treatment, she was coming to visits and testing positive for methamphetamine at that time.
Correct.
Now, is mother okay with the placement of the children where they are?
Yeah, she is very happy with the placement. Placement has communicated with mom via email, sent Easter pictures, and keeps her updated on doctor's appointments and such with the girls.
I noticed in your report that there are many relatives interested in placement. They've been checked and denied at this point, correct?
Correct. And I have not heard from any of the relatives about placement during this reporting period.
In my experience, if any of those relatives cure their defects and request placement, it's healthier for the children to be moved sooner than later. Would you agree?
Yes.
And we all hope for mother the very best, but we do need to consider the children's permanence. I don't know that what I'm trying to say is it appropriate to leave it with the relatives to contact you, or should we reach out to make sure what their intentions are?
Again, Mr. Stage, when he did his virtual parenting visit back in February, his parents were present, and I have not heard from his parents since that visit. So they do know how to contact me if they wanted to do a visit, if they wanted to be reassessed for placement. Again, they have the letter, they know what they need to do, and they know how to reach me, so.
Did you say they have a letter?
Yes, they have all of the placements that were initially assessed, all received letters with what needed to be corrected in order for placement to occur.
Very well. Could you send those letters to me after this hearing?
Yes, of course.
Thank you. I have nothing further.
I think that would be a great resource for us to have actually also. Don't mind. Just with your next court report. All right. Any redirect?
No, Your Honor.
Gentlemen?
Nothing further?
No.
All right. Thank you for your testimony. We return your seat. Testimony from any witnesses today, Mr. McFarland.
Let me see if Ms. McGee wishes to testify. Bonnie, do you wish to be sworn in to testify? If she's nodding her head yes, you'll have to unmute yourself, please.
Can you hear me okay?
We can't hear you.
Mr. McFarland, you might want to use the podium.
Thank you, Your Honor. I was looking for myself on here. I didn't see me. We accidentally lose her, perhaps.
No, she's here. She's reconnecting to audio.
Gotcha.
Her audio worked when she first logged in. I had to mute her.
Can you hear me now?
Yes.
Can you raise your right hand, please? Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Bonnie or Ms. McGee, you wish to add something today, is that correct?
Yes, I wrote a letter that I would like to read.
Sure, go ahead.
Okay.
If that's okay with the court.
Yes.
Yes, please do so.
I said addiction has taken the last 5 years of my life. Until 23 days ago, I didn't think I'd have the power to quit.
Okay, slow down. You gotta slow down a little bit because you're going too fast. I can't catch up.
And if you could speak up just a little louder, please.
Okay, I'm sorry. I said addiction's taken the last 5 years of my life. Until 23 days ago, I didn't think I'd have the power to quit, to knock the addiction out of my life for good. Only 2% of people that struggle from addiction get sober and stay sober. My goal is to be a part of that 2%, to beat the stigma, to prove that we do recover. In the 23 days that I've been here at Don Farm Sparrow Recovery Center, I've attended 46 AA NA meetings. I've met many sober supports and have a home group at the Washtenaw Alano Club that all will be here for me the second I think of using. I don't feel alone in my battle of addiction anymore. Also, in the time that I've spent here, I've learned many coping mechanisms such as reading, meditating, going for a walk, praying, and many more. But the most important being to call my sober supports and going to meetings, which I don't feel is a chore for me anymore.
Oh.
We're indulge her just a minute. We lost her momentarily. I hear she's rejoining.
I'm so sorry about that. My internet has kicked me off, so I am here by phone.
Thank you for rejoining us. Ms. McGee also had a little trouble with hers, so I don't think you missed too much.
Okay, great. Thank you.
We heard that it was not a burden to attend. That's where we last heard about Ms. McGee. Now we cannot hear you though. Stop. We have no audio. We're just going to try to rejoin with audio again, Your Honor. No, cannot hear you.
Can you hear me now?
You can, go ahead. Where you left off, you said it was not a burden attending meetings anymore.
And like that, she's done. Your Honor, if it's okay with the court, I'm going to ask her to send me a copy of the letter and I will include it in our next hearing.
Certainly.
Ms. McGee, can you hear me? I cannot hear you again, but before you try, if you'll send us a letter at my office, I will make sure that letter is attached for our next court proceeding, okay? Or you can bring it to the next court proceeding and I'll have copies for everybody, either way. But I'll let you try to finish. Can we hear you? No, we can't hear you. Okay.
Can you give us a thumbs up if you can hear Mr. McFarland?
Can you hear me?
Yes.
Okay, let's see how long it'll last.
Well, were you able to hear Mr. McFarland?
Yes.
Okay.
Could we maybe disable her visual, Your Honor? That may give us stronger audio.
It seems to be just completely dropping out. It doesn't appear to be a problem with her
Okay.
signal.
Okay, where you left off is attending meetings are not a burden anymore. Go ahead.
I have a sponsor and she was helping me work the 12 steps of AA. And I am thankful that I was sent here at the Dawn Farm, as the Dawn Farm way to recovery has honestly saved my life. Changed my addict brain into wanting sobriety, striving for it, because my precious daughters really do deserve a sober mom. And they'll get that forever. I will prevail. Thank you.
Does that conclude what you want to add?
Yes, sir.
Okay, I want to make sure we got you all. Thank you.
Anyone have any questions?
No.
No.
Ms. Heiss? Ms. Thomas, okay.
I have no questions. Thank you.
All right, very well. Mr. Brooks?
I'd like to hear from Mr. Stage briefly.
Mr. Stage.
Please raise your right hand, sir. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, Mr. Stage, there is an infant, Monroe Stage. Do you believe that's your child?
Yes, sir.
Now, for reasons I don't totally understand, a DNA test was not, or a sample was not taken when originally scheduled. Has it been taken now? Have you had one taken?
No, sir.
Anybody told you that it's forthcoming?
No, sir. I just heard the first of it when Ms. Brinker was speaking.
Okay. Now, you're in Monroe, or excuse me, Hillsdale County, right?
Yes, sir, till the 20th.
And then you're going to be transferred down to Ohio or Indiana?
I'm not for certain, but I'm pretty sure either Indiana or Branch County, one of the two.
I'm sorry, I couldn't understand what you said.
Either Branch County or Steuben County. I don't know for certain.
Those are both in Ohio, right?
No, one's in Indiana and then the other one's here in Michigan.
Oh, okay. What is the charges that are pending against you down there?
Aggravated assault, great extent bodily harm, less than murder, unlawful imprisonment, and felony in possession of a firearm.
Has there been a trial, or is that all yet to begin, that process?
It's at the end process. I just have to accept the plea and be sentenced.
Nice. Is there anything else you'd like the court to know?
That I just want the best for my daughters. And when I get out, I'm going to do what I can to make sure that they're all right.
Anything else, sir?
Yeah, no, sir.
I have no further questions, Your Honor.
All right, questions for this witness, Ms. Thomas?
Sorry about that, Your Honor. I don't know if it's necessarily a question for this witness, as just a question for the court and for the attorneys. If the parents both agree that Mr. Stage is the youngest child's father, if they would be willing to attest to that to make him legal father during this hearing.
I can answer that. I have difficulty with that because so many cases that has happened, and then we've had a motion down the road for a real DNA test. So I think I'd rather just proceed with the DNA.
Okay,
That's
thank you. Then I have no questions.
Mr. Brooks, any more questions?
No.
Mr. McFarland?
No.
Ms. Heiss?
No questions.
Thank you for your testimony today, Mr. Stage.
Yes, ma'am.
All right. Anyone else you'd like to hear from, Mr. Brooks?
No, there's not.
Ms. Heiss?
No witnesses today. Thank you.
All right, I look forward to your comments in closing then, counselors. Ms. Thomas?
Thank you, Judge. At this time, we are just asking for a standard review. We are grateful that Ms. McGee is in inpatient treatment that was recommended quite some time ago. And sort of, there was some resistance there. I know that there's going to need to be some time of stabilization when she is no longer in inpatient treatment. I think for those reasons, it is appropriate. I know that we're not at permanency planning hearing, but we would just ask for this case to continue on the path of reunification and set it for a 90-day review. Seems like there's good rapport with Ms. Brinker and Ms. McGee, and they are able to figure out the parenting time. As it relates to the pending show cause, I know that sort of was a byproduct of Ms. McGee's continued substance use at the late stage of her pregnancy, and needing really to safeguard that child. I don't think that it's appropriate anymore. I know that she's seeking treatment. She has maintained her sobriety for the last couple of weeks. So we would ask for that to be dismissed at this time. Thank you.
Okay, Mr. Brooks?
With respect to Mr. Stage, the road ahead is still unknown to us. And so I will have to rely on Ms. Brinker to keep us informed of what the outcome of the next step in his journey is going to be and what the results are. Then we'll know a little more about what his position can even practically be.
Mr. McFarland?
We have no objection to dismissing the contempt of court against my client. I think she has a good game plan of what she wants to do. I think we've heard, we've lost her again, unfortunately. I'll wait just one moment. She's reappearing. Thank you. She's here again. As I said, Mom has a game plan how to succeed. Matter of fact, that game plan is above and beyond, I think, what the court would order. That she wants to continue with daily drug testing to avoid any temptation, Your Honor, and to keep accountability on herself. And I think it's very poignant, her statement that she presented to the court today. And like any case, time will tell. We've lost her again, but I think we're on a really good path. So I would ask that we continue the permanency as a goal. Like I repeat, I would ask that we keep permanency as a goal. Thank you.
Reunification?
Reunification, Your Honor. Yes, thank you.
Ms. Heiss?
Yes, I agree with reunification as the goal, and I don't have any other closing. Thank you.
Thank you. The court finds all interested parties were given notice for purposes of today's review hearing. I concur, and I want to say I'm glad to see Ms. McGee doing well and taking ownership of her sobriety today and the fact that that means for her and her family, potentially. We still await the DNA testing for Mr. Schuyler's Stage, and he remains unavailable for placement. Ms. McGee is making progress, but she is not yet at the place where we can recognize that progress as a reduction of risk to the extent that I could allow the children to be returned to her. She needs to demonstrate a period of sobriety that we can all count on. Most of all, her children show us that she's been able to find a place to live that's safe and secure for the children, and employment so that she can support them and meet their needs, physical, medical, and otherwise. And they are in the safest and least restrictive placement where they are now, doing well in their foster care placement. So they will remain there pending our next review hearing. The goal of reunification will remain in place. I do find the department through the agency is certainly making reasonable efforts towards reunification. Thank you. Thank you also to our guardian ad litem and to our advocates. And that being said, we'll set our next court date as another look at permanency, but also a review of the services. Mr. Stage, if you're able to access any services in whatever facility you're at, please make sure that you forward that along to the caseworker and keep a hold of her information, and we'll ask her to do the same to sort of keep track of you as she has been, so that if there are some services you're able to get into, that you can share those with her and with us as well. We'll have our next review.
Will this also be a permanency planning hearing or not?
Yes, and permanency planning hearing. We have some time. Friday, the 21st of June at 9:30.
Your Honor, I will not be here that day, and I will make sure I put that on the calendars. On the 20th,
Yes, Your Honor.
24th.
I'm also out from June 21st through the 4th of July week.
Okay.
Must be nice.
Very well. So options include a hearing in front of the referee. Oh, no. Options include the second week of July. I guess, looks like we've got an opening. It may end up being in front of the referee at 9 a.m. on Wednesday, July 9th.
Okay.
Is that Tuesday the 9th or is that Wednesday?
Wednesday the 10th, sorry. Wednesday the 10th at 9. Will that work for everyone?
Yes.
Sure.
All right, so July 10th at 9 a.m. for purposes of review and permanency planning. Doesn't sound like there's any other major issues that need to be addressed today, other than to simply say good luck to our parents who are here today. Any questions?
Before my client leaves, can we get an address off the record as she'll be exiting her placement? I want to make sure we have a good place to get information to her.
Do you have that already, Ms. Brinker?
It's in my court report. It's the on-study address.
Yes, I think I heard that. She's returning to where she was residing before or at some point. So, thank you. And if anything changes as that
She's raising her finger.
Ms. McGee will expect you to give that information over as soon as possible to Ms. Brinker.
Okay, she's giving you a thumbs up, Your Honor.
All right, we're on record for a pretrial in this matter. I understand Mr. McFarland at least has had some time to talk with his client, so I look forward to the developments after appearances.
Lee Heiss, lawyer guardian ad litem. Nastasia Thomas, counsel for the department.
Christy Brinker, foster care worker.
Michael Brooks, I represent the father, Skylar Stage.
Michael McFarland, sorry.
I don't know that he's here. We've got the jail Zoom logged in. Is he, I think your client is supposed to be at the Hinsdale County Jail, Mr. Brooks, but.
Which county?
I thought Hillsdale.
Branch.
He's in Branch now. Just kidding, Branch. I'll have my assistant reach out to them to see what the issue might be there, but we've got the jail logged in, just no human. Mr. McFarland?
Michael McFarland, representing mother, Ms. McGee. Please introduce yourself for us.
Oh, God. Mother.
Sorry, that broke up. Could you do that one more time?
Bonnie McGee, mother.
Thank you. All right, while we await the arrival of Mr. Brooks' client, Mr. McFarland, would you like to give us an update on what your client would like to do?
Well, Your Honor, there was an indication that she might voluntarily wish to release. That is not the case, so we wish to proceed.
Okay, very good. I think we've already had the prelim. Looking for, let's see.
Are you on stage?
Yes.
Yes. Okay, thank you.
It looks like this, oh, I'm sorry, I was looking at the wrong thing, I thought.
Yeah.
Thank you. All right, so fourth review, permanency planning hearing, pretrial as it relates to the father. Thank you. I was getting ahead of us. All right. So let's go to your report whenever you're ready, Ms. Hicks.
Thank you, Your Honor. I visited with the children face to face. They are in licensed foster care. All of their needs are met. This is a very fortunate placement for the children. They have a caregiver home with them full time. They have another child in the home who has been adopted. So their life progress is understood by these caregivers who have a lot of resources to provide the children with vacations and all the normal things of childhood. So I visited them there, and the caregivers indicate that they're sleeping well, they're eating well, and that they're attending their visits. So then I have received and reviewed the investigation from our caseworker, and the recommendation is to change the goal to adoption. And I agree with that assessment. Mother is screening again positive after receiving some recovery treatment, and not consistent with her visits. And even at the visits, we're not seeing some real bonding work. So I would ask you to consider that the needs of the children are met in the current placement, and that I agree with the agency regarding the goal change. Thank you.
Ms. Thomas.
Thank you, Your Honor. If Ms. Bonnie McGee can please be sworn in.
Please raise your right hand. You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, before you get started, we have had one more person join us. Sir, could you give us your name, please?
Days.
Thank you, welcome. We've begun just with some testimony pieces. The only thing you missed was just the guardian ad litem update.
Ms. McGee, is it okay if I refer to you as Bonnie?
Yeah.
Bonnie, are you able to hear me okay?
Yes, ma'am.
Okay. So the last time we were in court was April 9th. Since that date, how would you describe, or how do you think your compliance with your case service plan has gone?
Up until like month and a half, 2 months ago, I really good, progressing really well, and just I don't know what happened. So
I'm just trying to understand. So you're saying within the last month and a half, 2 months, things have not been going very well?
no.
Could you move that phone or microphone a little closer to you, Ms. McGee? I think it's kind of picking up just the middle instead of.
Is that better?
It is, thank you.
You're welcome.
Okay, I know that the report indicates, well, first of all, have you had the chance to read the report?
Yes, ma'am.
I'm Kelly Clarkson, and you all know I want to raise my house.
Was there anything that stands out that you found inaccurate?
Yes.
Okay, and what would you say was not correct?
There was 2 things in there that one of them said something about me leaving Monroe unsupervised, and the other was letting Shelby roam around a public place without her being supervised, which both are like, I know they're not the truth, so I want to know why they were put in a case report or even said.
Okay, and that's something maybe I can ask Ms. Brinker about, okay? But it's your testimony that during that parenting time, the children were safe and you had supervised them appropriately?
Yes.
Okay. So as relates to your case service plan, I know that you had terminated your employment to go to Don Farms, and then it kind of took a while to get employment. Do you have employment today?
Yes, I'm at work as we speak.
Okay, and where are you working?
I work at Consolidated Packaging Group in Orland, Indiana.
Where?
Orland, Indiana. It's about an hour and a half from Adrian.
When did you move to Indiana?
The end or the middle of May. Maybe the end of June. I mean, the beginning of June, sorry.
And the report indicates that was with a romantic partner, is that correct?
Correct.
Okay. Are you still in that relationship?
Yes, ma'am.
Okay. Do you have, or do you care to share why the transitional housing with Don Farms was unsuccessful for you?
It was causing more stress than it was supposed to be relieving.
And how so?
Just that's personal. I do not wish to speak about that. If that's all right.
Well, part of your case service plan is includes, which your court ordered into, includes maintaining your sobriety and following recommendations from any substance abuse evaluation or treatment facilities. And so
Correct.
if transitional housing was part of that, the court would want to know, and the record should reflect what happened, that it was unsuccessful.
I was sexually assaulted. So I wanted to get away from there. So
Okay.
There's that.
Have you been able to talk about that or those conditions with the facility or with Ms. Brinker at all?
No, I haven't wanted to. I don't speak like that.
Did you report it to the police at all?
No, I didn't. This isn't relevant.
I didn't understand that comment. If you would like me to hear it, you'll have to repeat it.
No, ma'am. I apologize.
That's okay.
I know it's a hard thing to talk about, and so I do appreciate you letting us know what caused that. But with that, did you take any steps to continue any type of treatment to maintain your sobriety, especially after a traumatic event like that?
No, I think that's what caused me relapsing.
Okay. Are you indicating that you have relapsed since your sobriety?
Twice. Yes, ma'am.
And did Ms. Brinker go over the drug screening results with you today?
Yes, ma'am. Today.
Okay. And you are admitting that you did have a relapse that would have made you test positive on 6/18 and 6/27?
Yes, ma'am.
And the positive strains were for amphetamines and methamphetamines?
Yes.
And if you were to be tested today, would you still be positive?
I'm not sure.
Okay.
No.
In Indiana, are you participating in any AA or NA or anything related to your substance abuse or sobriety?
I've been to a couple of NA meetings, yes.
Are you currently in therapy at all?
No. I tried, but it was a conflict of interest because the girls' father, their aunt is the only one that is a therapist where they, like, the first place I was trying to go. So I couldn't go there, so I'm waiting to hear back from a place called the Bowen Center in Angola. But with my work schedule being so crazy, I literally don't know when I have time.
And have you reached out to Ms. Brinker to get assistance or just have someone to support you in finding a therapist or another treatment facility for you closer to where you're currently living?
No, ma'am, I have not.
The report indicates there's been some inconsistency with parenting time. That you've missed 11 visits this last review period, that you've also ended a few early. Do you have an explanation for those?
No. No, ma'am, I don't.
Okay, that's okay. Have you considered what that might be like for the girls when you're inconsistent with parenting time?
Confusing.
Moving forward, what are the barriers to being consistent with parenting time as scheduled?
Can you say that again? I didn't understand.
Moving forward, if you do have parenting time, what would be the barriers to being consistent with that?
So my work schedule is 4 a.m. to 4 p.m. and I live an hour away. Like, my work is an hour and a half away from Adrian. So I get out at 4, so I'd be there by 5:30. And I guess the only barrier would be like the gas and the girls getting home so late.
And do you realize that's something that Ms. Brinker can also talk about with you and identifying dates that you have?
Yes, ma'am.
Is there anything else that you would like the court to know?
Not at this time, no.
And just for the record, when was the last time that you used?
The 26th of June.
I'm sorry, did she say this morning?
The 26th of June.
Oh.
Correct, Ms. McGee?
What was that?
Did you indicate June 26th?
Yeah.
Well, I have no further questions, but the other attorneys may, okay?
Okay.
Mr. McFarland?
You realized that part of the reason that the principal reason this case was opened was because of your drug issues, correct?
Yep. Yes, sir.
And you've heard that they wish to change the goal from reunification to adoption, which would mean termination of your parental rights. You understand that's what they're seeking, do you?
Yeah, yes, I do.
Now, the worker may be able to assist you if you came back to Michigan with getting into another program that's safer for your drug addiction. Do you understand that?
I don't feel as though I need another rehab. I feel as though I need a safe, consistent housing, which I got a list of phone numbers for in the beginning. None of them help.
Well, let me ask you this before the guardian ad litem does. but you went through drug rehab, you're discharged, and now you're testing positive for meth twice, and you're telling us that you don't need drug rehab. I'm here to be your attorney to help you so you don't lose your kids. Just wondering, would you give consideration to another inpatient? Because it obviously whatever happened didn't work. I realize the trauma, but would you consider that?
Yeah, yes, I would.
And you realize that inpatient means you're not going to be working because you'd be focusing solely on your job, right? Or on your job of getting off of drugs and not employment. You understand that?
Yes, and that's why I said I don't need it, because I can stay sober, but I can't just make money pop out of nowhere. I have to have a job.
Okay, I'm trying to for the court to understand your logic. Okay. If you die of an overdose, you know, a job doesn't make a difference for the kids. I'm just trying to let you know where I'm going. I'm trying to let you know that they're trying to terminate your rights. I'm just letting you know what's the options that are available, okay? Have you considered coming back to Lenawee County where the agency can help you with services?
If I'm able to get, yes.
Well, rather than us have this discussion here in court.
That's all I need with, because I know I can stay.
Rather than us having this discussion here in court, would you be receptive to a family team meeting where you can sit down with the worker and you can discuss what options are available for you to return to Lenawee County to get back on track? Would you be agreeable to doing that at least?
Yeah, yes.
Anything else that we need to add?
No, sir.
Okay.
Mr. Brooks.
Well, I am curious. Ma'am, I represent the father of your children, okay?
Yes, sir.
And I'm just curious. Did you move so far away to get away from the perpetrator of the incident you told us about? In other words, did you run away from that guy?
Pretty much.
And he's up here?
In Ann Arbor, yes.
I'm sorry, what?
Arbor.
Okay, so you moved to Indiana. Part of your motivation, at least, was to get away from him, right?
Yes.
That's all.
Yes, nice.
How long have you been employed full-time?
Going on 3.5 weeks.
Okay, is one of your goals to bring to visits the things that children will need while you're there?
Everything they need.
Okay, that's a goal of yours. Have you been able to do that yet?
Not exactly yet, but yes.
Okay, and then
at my house.
You have the things you need?
Yes, I do. But I only missed my last visit because I was at work and I didn't see what time it was. And the confirmation time is 8 a.m. And I didn't send the text early enough.
Okay, and then does your budget allow you to keep current on diapers and wipes and those kinds of things?
Yes.
Okay.
At my last visit.
Go ahead.
At my last visit I attended, I didn't have diapers for Monroe because I thought I had some in the diaper bag because I buy a big pack every time I do. I thought I had some in the diaper bag, but I didn't.
I don't have one either.
So I had some at home, but I just not in the diaper bag.
Okay, I have nothing further. Thank you.
Any redirect?
No, Your Honor.
Any recross?
No, thank you.
Good. Your next witness, Ms. Thomas?
I'll call Mr. Skylar Stage.
Can you hear me, sir?
He's got he'll need to unmute on your end if you can.
There it goes. Can you hear me?
Yep, we can hear you now. Please raise your right hand.
Yes, sir.
Do you swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
Hi, Mr. Stage. I just briefly wanted to see how you were doing in this last review period. I believe that you are at Branch County now.
Yes, ma'am. I'm waiting to be sent out to prison.
Okay. And do you know any details yet? I know the last time you were still waiting.
August 12th, I get sentenced. I'll ride out the 13th to the 14th to MDOC for quarantine.
Okay. And I know that at some point there were talks about you having to be extradited to Indiana. Is that still the case?
No, ma'am. I signed my extradition rights for my time. The time that I'm serving here, I'll be discharged from everything when I'm done with this time.
I can't understand anything. Is there any chance you can get a little closer to whatever microphone that is, or just speak up and just slow down? That might help too.
So I got extradition papers. I waived my extradition. So technically my time is being ran concurrent with the time that I'm doing now. So when I get done, I'll be discharged from any disciplinary actions that are being held for me in Steuben County, Indiana.
Okay. Okay. And have you been able to receive like the paperwork that Ms. Brinker sends to Branch County, like the court report or anything like that?
Yeah, I just got the case plan.
Do you have the means to send any communication to Ms. Brinker while you're at Branch County, or does it have to wait until you're sentenced and sent to her?
I can. I just ordered envelopes this week actually, so I can write. And yeah, I was gonna continue to follow through with my my Narcotics Anonymous, my read book. I was gonna. You can't hear me?
I'm sorry. I can't understand what you're saying, sir. I'd like to, because it sounds like good, positive updates for you. So could you try that again for us, just a little slower and a little louder?
All right, so I bought some envelopes so I can write. They'll be here when store gets here. Now, on the other hand, I have the Narcotics Anonymous book. I've been reading through that, and I was gonna fill out paperwork to send in to the case manager, because it says that in the case service plan, that's something that I gotta abide by. I was attending the meetings that they have here, but my security classification doesn't allow it anymore. So now I'm just waiting to ride out so I can fully cooperate with the case plan to my best.
Do you have any indication how long sentencing is for you?
Sentencing, I'll be sentenced on August 12th.
Okay, but you have no idea if it's like 4 years or 2 or anything like that?
I've got 17 months to 10 years, but as long as I have good behavior, I'll be out in 17 months on parole.
Okay, all right. And are there any other services that you're participating in with Branch County?
Not that I'm allowed to with my security classification, but I do personally attend to my cell. I read a recovery Bible. I've been working the 12 steps. You know, I weigh a lot of my personal interest on higher power for spirituality to try to get through everything that I'm going through. And I've also done job works, which is for employment once I am re-entered into society from incarceration.
Okay. Okay, thank you for that update. And then the last thing that I wanted to ask about was if you received the DNA results for the youngest child in this case.
Yes, ma'am, I did.
Okay, and so you understand that you are considered the biological father?
Yes, ma'am, I understand that.
All right, thank you. I have no further questions, but other side, okay?
Yes, ma'am.
Mr. Garland?
No questions.
Mr. Brooks?
Mr. Stage, I'm your attorney, and a couple of questions I have. If I understand your testimony, you have been found guilty of some sort of crime or another. Is that correct?
I pled no contest.
I'm sorry, what?
I pled no contest.
Okay, you pled no contest, I understand. What was the charge you pled no contest to?
There was 3 of them, sir. The first one was aggravated assault with great intent bodily harm, less than murder. Count 2 was felonious assault with a dangerous weapon, and then count 3 was felony in possession of a firearm.
So you've pled no contest to 3 felonies. Have I got that right?
Yes, sir.
And you won't know when your sentencing is, or you won't know what your sentence is until the middle of August. Is that accurate?
The plea that I signed is 17 months to 10 years, so I have a general basis on what I'm going to be doing.
All right. Is there anything else you want the court to know?
I apologize for my criminal tendencies that have placed me here, but I do sincerely love my children, and I would like to provide for them. So if it's possible to hold off, if anything, to where I can possibly have a chance to prove myself to the court when I am released from incarceration, because I do not feel as it's fair that since I've been locked up that I have not been able to fully put myself in front of everything and take care of it.
All right, thank you.
Thank you.
Ms. Heiss?
Mr. Stage, in your no contest plea, there was an alleged victim. Was that a domestic partner? Who was it?
It was. It's hard to explain. It wasn't a relationship, but.
So it wasn't a police officer or a store owner. It was a friend.
It was somebody that I was seeing within the bedroom. We weren't in a relationship, but at the same time, we were having more benefits of them being a friend.
So a girlfriend kind of thing?
I guess so. That's what we put it as, yeah.
Okay, nothing further. Thank you.
Any redirect?
No, Your Honor.
Any other witnesses?
I'll call Ms. Brinker just to get the report in. Thank you.
All right. Coming up. Yeah.
You swear or affirm to tell the truth, the whole truth, nothing but the truth, so help you God?
I do.
Ms. Brinker, before us is a court report with some attachments. Are there any updates or modifications that need to be made to that report or the attachments that you're aware of?
Yes, as Ms. Heiss already mentioned, on page 5, just in part C, discusses Bonnie's substance-free lifestyle. I do have the printout of her 2 positive drug screens that I would like to be admitted.
Okay.
Could you speak up, please?
I'm sorry, yes.
Okay. Do you have copies for all the attorneys? I know that.
Yes, Ms. Heiss has hers. Mr. McFarland can have that one, and I have an extra one.
I have no objection since my client admitted to it.
Thank you.
I'll need a copy.
I was just here under me. Someone help.
That's okay.
Ms. Heiss, did you have any objection to the admission of this proposed exhibit?
No, I have received and reviewed it. I have no objection.
Mr. Brooks, same question.
No position.
Thank you. I will receive it based on the agreement of the attorneys and Mr. Brooks's position. Go ahead.
Thank you, Ms. Brinker. Any other modifications?
Yes, the other modification is that noted on a family member had come forward regarding placement information. It was on page 3 that Ms. McGee had expressed interest in releasing her rights to potentially Mr. Stage's aunt. And she had texted me this morning and said that she was no longer interested and no longer wished to be considered.
Okay.
And that would be all the updates.
At this time, what barriers exist to reunification for the children?
Pretty much everything listed in the initial reasons for removal exist still as barriers for returning the children. Ms. McGee still does not have appropriate housing. She still is demonstrating let's go through the case service plan. She's does not have a stable home environment. She's not participating in her services. She did complete the Dawn Farms. And then even upon release, she did not attend her aftercare at MVA here locally. So she lived locally for a month and did not attend services there. So she's been struggling and participating with her counseling and keeping up with her substance abuse. The third thing was her substance-free lifestyle, which we just heard that she tested positive and is not really participating in doing any kind of preventative maintenance, nor is she really open at this point to going back into an inpatient kind of facility. She has not participated in her domestic violence services. That was going to be wrapped in as part of her counseling services, which she has failed to engage in. The next section is parenting time consistently. Again, that's been very sporadic, has not been able to provide for the needs of the girls. There are concerns regarding her ability to supervise and her bonding with the girls. So those are the main barriers at this time.
Regarding parenting time, the report indicates, I believe, if I remember correctly, parenting time is on Saturdays? Or
that it was on Saturdays when she was up at Dawn Farms.
okay, and when is it scheduled to take place now?
Currently, it's 3 nights a week. We did increase her parenting time because she was demonstrating sobriety. And so she had asked for more time, so we had increased parenting time.
Since the increase, has there been more inconsistency?
Yes.
Your report indicates that at this time, well, let me go back. So all the barriers that you just mentioned, what services has the agency offered during this review period to help address those concerns?
So I do meet with Ms. McGee pretty regularly just because I know she's struggling to connect with services. So I try to be there. If I'm not supervising the parenting visits, I try to be in the office so that I can meet with her, to touch base with her. We just met on Tuesday and we talked about, what I could do to help her. I offered to help her with gas cards, to help her visits. I offered to instead of doing visits 3 days a week, do visits 4 days a week for a shorter duration. That way the girls aren't getting home at 8:30 at night. So we have talked and discussed different options. We have talked about, you know, the distance obviously is a huge barrier now that she has elected to move an hour and a half away. And unfortunately, most of our Lenawee County connections that she had, you know, it's a little bit harder to find stuff in her locality. And it appears at this point that she has also decided to put her employment first. And I really have been stressing with her that I need her to put her sobriety first. And she kind of made a shift, and that's when that happened is when she started using again, it looks like. So
it's similar to where she was, I think not maybe the last review period too, where she was really unwilling to terminate employment to go to rehab.
Right, correct. And she actually, when she came back from rehab, her employer, which I think was great for her here locally, very flexible with her and kind of let her modify her schedule, held her job for her while she was at rehab. So she was working there for about a month or so when she got out of rehab. And then she just one day told me that she wanted to quit so she could focus on going to meetings. And then I started checking with MBA, and she just was not going to meetings or doing anything to encourage her sobriety.
Today, you're recommending a bold change to adoption, correct?
Correct.
Are you recommending any change to parenting time?
There's only been one incident where the older child displayed some concerning behaviors, but at this point, I am not recommending any changes to parenting time.
And so you're still comfortable with the 3 hour or 3 times a week?
Yes.
If she continues to be inconsistent, what would the plan be?
To file a termination and suspension of parenting rights.
And then as relates to Mr. Stage, we've been waiting for DNA results for quite some time, I believe. But it looks like we have those back.
Correct.
And he's indicating to be 99.999% the youngest child's biological father.
Correct.
Okay. Is there anything else that you would like to highlight from your court report, or just inform the court on, like how the girls are doing or how placement is placement willing to provide permanency?
Sure. The placement is, as Ms. Hyde said, wonderful. Licensed foster home. They are willing to provide permanency to both of the girls. Both of the girls, Shelby has been in the home for a year now. So the girls are very bonded to them, and they're willing to provide permanency. Also, as Ms. Hyde said, that they have previously adopted another child and with similar substance abuse issues. And as the mom, she's continued the relationship with the mom post adoption. So she keeps that relationship open. So the family is very familiar with adoption and the importance of the biological family in a child's life when safe and appropriate.
Okay. Thank you. With that, I have no further questions. We move to admit the court report with the attachments.
No objections.
No objection.
I have no objection.
Thank you. They are received. Cross-examination, Mr. McFarland.
Thank you. I'm going to approach the podium so my client can see me. My presumption would be that you're unaware that my client was sexually assaulted, since I don't see it in your report. Would that be accurate?
Yes.
Okay. And I know your perception is that she doesn't want to go to rehab or to do anything, but you did hear that she is receptive to discussing these things at a family team meeting and not a public setting like this, in a more private setting.
We have this discussion pretty much every other week. Again, I try to sit down with her just for the extra one-on-one attention and to explore all of her options.
Well, it sounds as though she might be starting to open up, and you can understand that if she were sexually assaulted here in Ann Arbor, so close to Adrian, you can at least understand why she wants to get away from those memories, those thoughts, correct?
Miss McGee had told me that the reason she left the residential housing was because they demanded too much of her. And it was too much, that the therapy, the group settings, the individual therapy, that it was too much for her. That is the reasoning that she gave me.
It could be that she was trying to shield herself from what really happened also, correct?
Perhaps, yes.
Would you be able to provide resources here locally for her, for counseling for that if she so chose?
Yes, I feel like she had a good bond going with her therapist at MBA, so I was surprised to learn that she discontinued services with her and chose to move the hour and a half away.
Do you think that these could be reestablished if she wished to do this by Zoom or otherwise?
I don't believe, well, she's not eligible for the services if she's not living in Lenawee County.
Okay. And my understanding is it's very difficult for you here in Lenawee to try to secure in Indiana services for her, correct?
I can make the referrals, but that's
about it. So it'd be much better if she could move to Lenawee County. Is that what I'm hearing really?
correct, yes, would be beneficial.
If she were to re-engage in her case service plan, would she need another assessment to see? Because I know McCullough Vargas has an intensive outpatient program that would still perhaps allow her to work and maintain some independence. Do you think another assessment might be beneficial?
That would be up to McCullough Vargas, I can't speak for him.
Well,
But
would you
yes.
would you object to her getting?
Not at all, no.
Okay, okay. She wants to have a family team meeting, which would involve the guardian ad litem, herself, and you. Are you agreeable to that? I'm
Yes.
asking. Okay. What about concurrent planning, which the court would consider both adoption and or reunification based upon the revelation that she herself has gone through a trauma and is healing and naturally take some time. What are your thoughts on that?
I'm in full agreement, as I spoke with Ms. McGee before I wrote the court report at the end of June and told her that I would be making the change of recommendation for adoption. I explained to her that it wasn't termination, that I hoped that she would continue to be working towards reunification. And again, have touched base with her more regularly to try to encourage her to re-engage in her case service plan.
Basically, if I hear you correctly, you're asking this court to consider either reunification or adoption, which would be termination of her parental rights, depending on what she does in this next reporting period. Did I hear you correctly?
Correct.
So you want her to really step up because this is her, in your opinion, her last chance to be a parent, correct?
Yes, correct.
I suppose, just for the record, part of your thinking is that in a child's life, time flies by so much faster than it does for an adult. Is that correct?
Yes.
So it's the first step for her to keep that meeting with you that she wishes to have in the guardian ad litem. Proceed.
Yes.
And then you would prioritize for her and recommend what she should do with that. Is that correct?
Yes.
Okay. Nothing further. Thank you.
Mr. Brooks?
Would you agree with me that the father in this matter, given his present circumstances, has limited opportunities to improve his position relative to this case?
I do agree with that, yes.
That's all.
Ms. Heiss?
3 sets of relatives have been assessed for placement or for, and 2 were denied by the agency, correct? 2 sets?
I believe, well, everybody that has been assessed has been denied.
Didn't one person back out of the
Yes,
process today?
yes.
So, okay. And then, but you did investigate the suggestions that the parents have made. There were a lot of paternal relatives.
Correct, yes.
Yeah. And there isn't any other relative identified for placement at this point?
That would be appropriate now.
Okay. And okay. when mom was, in your report, it says that mom at one point was considering a release. Do you know if she was sober or was she using during that period where she was considering a release?
I do not know.
Thank you. I have nothing further.
Any redirect?
No, Your Honor.
Any recross?
Nope.
No.
Thank you for your testimony. You may return to your seat. Witnesses?
No, Your Honor.
Mr. McFarland?
I recall my client, please.
She has been sworn.
Bonnie, do you understand the worker just said she's recommending kind of a two-part request, which is one, either we reunify, or two, we terminate your rights, which is adoption, based upon what you do in this next period. Do you understand that?
Yes.
I didn't hear that. It kind of cut out.
Yes, I do.
Okay. Hearing everything that was said, is there anything else you want to say as far as how you proceed forward on the case service plan?
You're not going to recognize me at the end of this.
I didn't quite hear that. Can you repeat that?
I said you're not going to be able to recognize me at the end of this.
Does that mean, tell us what that means.
That I'm going to do what I need to do to get my children back.
You heard the worker say that it's so difficult to help you in Indiana.
Yes.
What are your thoughts? What are your thoughts about moving back here where services might be more available for you?
I'm not sure at this time. I need time to think about it.
Okay. Can you maybe tell us what your thinking is, why you might not want to move back, just so the court knows?
My drug of choice is everywhere around there. The person that I hope I never see again is up there. I feel safer in Indiana.
Okay. So you'll discuss all these things at the family team meeting where we can do that, okay?
Correct.
Okay, nothing further, Your Honor.
Any cross-examination?
No. No.
No.
Thank you. Any other witnesses?
No, thank you.
Mr. Brooks?
Mr. Stage, is there anything on your mind that you want to tell the court?
All right, we'll have to have him unmute again, but he's shaking
He
his head.
said no, Your Honor.
Okay.
He shook his head no.
Thank you. Ms. Heiss, any witnesses?
No witnesses, thank you.
Comments?
Your Honor, just a point of clarification for the procedural process of this case. I know that Mr. Stage already is adjudicated and has case service plan for the older child. And I just didn't know how the court wants to proceed now that we have the DNA back for the younger child.
Why don't we resolve the review and then we'll tackle that question.
Thank you, Your Honor. At this time, Judge, the agency is requesting a goal change to adoption. We understand that Ms. McFarland may propose a dual goal for reunification and adoption. Judge, at this time, I believe it's been about almost a year since we've had one of these children in care. And in the last year, I believe Mom has only more recently taken sobriety more seriously to get into treatment. And even then, not maintain that. And whether, and I don't want to say that she was being untruthful, but whether she experienced trauma in the facility during her transitional housing, or she just felt it was too much. After that, there was no response. There was no, let me get back to Nicola Vargas, let me check in CMH, hey Christy, can I have some support here? Even if she didn't want to talk about it at that time. But it just to me, that demonstrates this lack of benefit from services to date. And again, like not being in therapy is also not conducive to establishing a stable lifestyle for these children who are very young. And we have one child, I believe both actually were born drug exposed, and they're going to need to have that stability from their caregivers and opportunities to develop in a safe environment And right now, neither parent can provide that. Mr. Stage is incarcerated and has been for a majority of this case, and will continue to be for anywhere from 17 months to 10 years. And for these little ones, that's a really, really long time to wait. They're essentially their entire lifetime. So for those reasons, we are asking the court to change the rule to adoption. As relates to parenting time, I know that Ms. Brinker had stated that she is fine keeping parenting time as is. I will defer to the LGL to make an opinion on that. I know that the safeguard in place is the confirmation at 8 a.m. And maybe that prevents some sort of confusing experience when children are being transported parenting time and not having it. But I don't think it resolves the issue of children being confused when they see a person or their mother once a week, every week, and then some weeks there's none at all. And so with that, I'm requesting no change at this time, but continuing to make it supervised. With that, we'd also ask just for standard 90-day review in hopes that Ms. McGee can find some stabilization, as she's the parent who has the ability to do that right now. Thank you.
Comments, Mr. McFarland?
Your Honor, when I had the worker clarify her position on the stand, whether it was dual adoption and or reunification, she testified that yes, that was. So we would ask that the court have that as the goal, not just adoption, which would be termination of parental rights. I can only imagine how painful it was for my client to testify that she's been a victim of sexual abuse. I think we can all understand why the stigma that often accompanies that, why she doesn't want to say that that is a real reason for her move. I think we can understand why that triggers. I think we can understand how that would trigger a relapse. My client is willing to have a family team meeting to see what she can do. I think we also have to be sensitive to the plight of her as a victim. I think she'd be more creative and say something that wouldn't put her in such a position today if she wasn't telling the truth. I think that she was telling the truth here today. She knows what direction she has to take, so we are asking for a dual goal rather than just adoption, Your Honor. Thank you.
Mr. Brooks?
I think my client's position will be a lot easier to interpret, make decisions on after his sentencing date. And so we'll look at that again at that time, after he's been sentenced.
Ms. Hanks?
Yes, Your Honor, I think that to continue the supervised visits at the discretion of the agency, you don't want to give more than the mother can be successful at, but you want to give as much as we can to continue the bond. And the children's needs are being met in the meantime. I guess that concludes my comments today. Thank you.
Thank you. While the court finds all interested parties were given notice for purposes of today's review hearing, I will note the proceedings as it relates to Skylar and the youngest child have been at pretrial stage given the request for DNA testing. The court has received those DNA test results today, indicating 99.99% probability that the youngest child is indeed Skylar Stage's child, also indicating legally that he is now recognized as legal parent. So, Mr. Brooks, I will ask you to talk with him about how he wishes to proceed moving forward, potentially after today's review hearing. So,
and the name of the child is, again?
Monroe.
Monroe. You want me to do this now?
Well, Mr. Brooks, I think I'd like to have a brief bench conference before we ask you to talk with him about how you'd like to proceed. So, if you would be so kind to give me just a few minutes. As it relates to the review, both parents have been subject to dispositional review hearings for several months now. Mom's initial disposition was conducted August 17th, 2023. Father's initial disposition on the first petition was October 3rd, 2023. Their case services plans have remained the same during that period of time. up through today. The challenges have remained the same. Skylar Stage remains incarcerated. He has been incarcerated for the duration of the case. More cases continue to plague him. He is looking at a sentencing that will require a minimum of 17 months on the first case, and he awaits disposition of several other cases that will likely only increase that time. So he will clearly be unavailable to the child despite any services that he might be able to undertake for a very significant period of time moving forward. Too much time, frankly. In the name of permanency and stability, we cannot consider him for the purposes of the goal of reunification for either child really moving forward at this point, given his circumstances. As it relates to Bonnie McGee, again, she's had the same case services and challenges since August 17th, 2023. Obviously, before that, the initial removal of the first child was July 10th of 2023 in Branch County. And I'm reviewing the report, I'm listening carefully to the testimony, and I'm also looking at the exhibits. So I hear that she wants us to sympathize with her about an alleged sexual assault, but I just cannot find that that is credible today. She has made statements completely contrary to what Ms. Brinker has reported. The initial comments that she made to Ms. Brinker about leaving was that simply that it was too much. There were too many meetings. There was too much for her to do in order to tackle her sobriety. She has made no police report alleging a sexual assault. Her move to Indiana is reported in the court report, and also, according to her own initial testimony, was to join a new romantic partner and his parents in Indiana, and did result in the discontinuing of all services. She had been involved in those rehabilitation services as well as services through McCullough Vargas. However, the McCullough Vargas reports indicate, quite frankly, that they had significant concerns about her progress even when she was engaged, as she disclosed pretty openly that she had been using alcohol on the weekends to, quote, relapse, quote. I'll quote directly from the report dated May 31st, 2024. Allison, it looks like Ferguson maybe, Fulgenti, I'm sorry, the CAADC therapist. This is of some concern as she does not feel this is a problem because, quote, it is not a drug, quote. There were two diagnoses that McCullough Vargas was attempting to support Ms. McGee on. First was stimulant dependence, and the second was borderline personality disorder. Those two things indicate that there are mental health issues as well as substance abuse issues that continue to be outstanding. She has not done anything to engage in domestic violence education services to prevent that situation from recurring. She's disengaged in all therapy, treatment, support groups otherwise, and this court's findings been disingenuous about the reasons for that. I cannot, in good conscience, frankly, allow further report periods without changing the goal given those circumstances. The goal for both of these children will be adoption moving forward. They're safe, stable, doing well, and with her beginning to miss more and more visits, the only stressor that these two children have exhibited have to do with her missed visits. That's affecting the children negatively. Obviously, the mental health of the oldest child, who's showing some self-destructive indications based on the confusion and the inconsistency in parenting time. So I can't, again, I have to look at what is in the best interest of these two children. They need permanency, stability, they need their situation stabilized, and they need to understand that they can just focus on what they need to do moving forward. They're very young. They've been in care for a significant period of time. July 10th of 2023 for the oldest child, February 16th of 2024 for the youngest child, which may not seem like a lot, but as was argued also, these are very young children. So for the youngest child, that's the entirety of her life. And for the older child, we're coming up on half of her life. So it's time to make a decision. There will be another review period during which I will expect the department to draft and file a termination petition as it relates to both children. And I'll look to these two parents to decide what they want to do in the meantime. I will obviously look at any additional progress that Bonnie McGee makes in the next report period. But from where I'm sitting right now, I have to do what's in the best interest of these children, and that needs a goal change. Unless there's any questions, that's all for the review. We'll ask the jail to leave Mr. Skylar Stage on for a bit so that you can talk with Mr. Brooks after we've had just a brief bench conference. Unless there's any questions, that's all for today.